just ask you, I'd understood them to be complaining about the procedures. Am I completely off base here? You suggested that they're complaining about not getting enough loan forgiveness or something. Maybe I misheard you, but I thought they were trying to bring a procedural claim, and that the reason why this was problematic was because the procedures that they are saying are lacking are actually under the other source of authority, that if we looked at the source of authority that the secretary used in this scenario, it doesn't guarantee them those procedures. So you can't really complain about not getting procedures in under another statute that was not invoked in this situation. Am I wrong about this?
No, and I understand the confusion because the theory here is a little convoluted, and so let me try to unpack it. They are asserting a procedural injury, but what they're saying is we want an opportunity to comment on loan forgiveness so it'll include us as well. Our underlying injury is that without having a chance to comment on the Secretary's use of authority under the HEROES Act, we didn't get a chance to advocate for us to be included in the plan. The problem with that procedural theory of harm is that by their own arguments in the case, the Secretary couldn't make a different decision. He couldn't go back to the drawing board and think about it and decide, yes, I'm going to expand the plan under the HEROES Act to provide these borrowers with relief too. So they aren't able to assert that kind of redressability for an asserted procedural injury under the HEROES Act.
And that's because there aren't negotiated procedures under the HEROES Act.
Right. The statutory text is very clear. So even if you were to get to it on the merits, they haven't actually been deprived of any procedural rights. The HEROES Act specifies that waivers and modifications issued under the HEROES Act are exempt from notice and comment. But I think because of the fundamental flaw with their theory of injury and the fact that it couldn't be redressed by their own arguments in this case, they've now brought up this Education Act idea. They haven't been deprived of any procedural rights under the Education Act. You know, procedural rights derive from specific agency decisions under agency authority. So it's not as though they have some procedural right in the ether to just comment on the concept of loan forgiveness writ large. Instead, under the HEROES Act, as we've just discussed, there isn't a notice and comment procedural right. And under the Education Act, no decision has been made. And so they haven't been deprived of any procedure associated with that decision.
So what they would need, I suppose, is certainty that if we nullify the authority of the Secretary to do what it did in the HEROES Act, that there would necessarily be a loan forgiveness program under the HEA.
Yes, and they can't make anything like that showing here. It's total speculation on their part to suggest that if the Secretary is blocked from taking this action, maybe he'll look for a different source of authority and issue an entirely different program under that source of authority. And I think that that shows that their theory is unduly speculative here. I think it's important to recognize as well why they're pressing this claim and the upshot of this theory. The reason they're asking the court to go down this road is so that they can effectively raise a substantive challenge to the HEROES Act. That was actually the only claim on which they prevailed below. The district court in this case rejected their assertions of procedural harm and instead went on to resolve a standalone substantive challenge to the Secretary's plan and said that it was unlawful under the HEROES Act. But they've now entirely abandoned that basis for prevailing below. They say that the district court was wrong to consider that. They're not defending that ruling. And it makes good sense because they obviously lack standing to maintain a substantive standalone challenge to the HEROES Act, since that wouldn't do anything to redress their harm, but instead just ensure that they aren't going to get any debt relief. By raising this procedural argument, though, they're effectively asking for an opportunity to raise the very same substantive claim that they lack standing to pursue through the guise of a procedural challenge to the Act. And there is no apparent reason for the court to allow that kind of gambit and to take what is actually a substantive challenge based on a generalized grievance with how the executive is administering the law and alter the ordinary Article 3 standards to allow a plaintiff to revisit that conclusion through a procedural mechanism.